All right, it is the 7 o'clock hour. We are live on Zoom. There is a technical issue with YouTube, so we're just have to upload the video essentially this evening or tomorrow once it's complete. Apologize about that, but we are ready to roll on Zoom.
Thank you, Chris. I'd like to call this meeting to order. Do a roll call on all members here. Member Vest, missing, Mr. Faber, Mr. Mullen. Mr. Powers?
Here.
And I'm here. Just something I'd like to note, in addition to citizens attending the meeting in person, citizens have several options to view or participate in the Zoom meeting webinar described as follows. We will do our best to take citizen comments remotely. There are two options for citizens to offer comments. One, to join Rockbridge County Board of Zoning Appeals Zoom webinar. Links available on the county website to copy into the address line of your favorite web browser. To join by telephone, you may dial into one of the numbers listed on the county website. Webinar ID and password are there for your convenience. If you wish to make a citizen comment as a Zoom meeting participant, you will use the raise your hand feature. You can press the raise your hand button at the bottom of your Zoom window, or press *9 if you're calling in by telephone. At this time, I'd like to proceed with the meeting. First thing we need to call is the election of officers.
Yes. At its March 18th, 2026 meeting, the Board of Zoning Appeals held the election of officers for the upcoming year. The BZA elected Mr. Jeff Pufall to serve as chair, Mr. Greg Mullen III to serve as vice chair, and myself, Chris Layden, to serve as secretary. Per BZA bylaws, per the Board of Zoning Appeals bylaw, Article 1, Section 1/4, the zoning administrator is required to serve as secretary. At its April 13th, 2026 meeting, the Board of Supervisors appointed Mr. Jason Tyree to serve as the zoning administrator. Therefore, the BZA is required to hold the election of officers to elect Mr. Tyree as the secretary. This does take a motion and a roll call vote, if the board desires.
All right. Anybody like to make a motion? Roy?
I move we select this.
Fine young gentleman.
Yes.
I'll second.
All in favor? Aye.
Aye.
Opposed? All right. Motion carries with a unanimous vote. At this point, I believe we need to review the minutes of the last meeting. And this does carry a motion.
I move to approve the minutes from February 18th.
All right.
6.
Second.
Second. All in favor?
Aye.
Aye. Opposed? All right. Motion carries a unanimous vote. We have next on our agenda. Okay. Next, we've got the appeal of Donald P. Jeffer Jr. and Jeannie L. Jeffer, appeal of May 1st zoning determination letter pertaining to the USS Hilltop LLC.
Prior to turning over the floor to Mr. Tyree, I'd like to go ahead and read the notice of public hearing. Notice is hereby given per section 15.22204 of the Code of Virginia and Chapter 30, Article 8, Section 30-83 of the Rockbridge County Code that a public hearing will be held by the Rockbridge County Board of Zoning Appeals on Wednesday, July 15th, at 2026 at or after 7 p.m. in the Board of Supervisors meeting room, County Administration Office, 150 South Main Street, to consider an application for appeal of the zoning administrator's decision by Donald P. Jeffer Jr. and Janine L. Jeffer, address being 200 Black Bridge Lane, Natural Bridge Station, Virginia 24579. The appeal pertains to the May 1st, 2026 zoning determination letter by the zoning administrator related to the interpretation of the conditions associated with a previously approved special exception permit to develop and operate a 3.00 megawatt AC power solar project. Property is identified as tax map number 113-5-D as in Delta, and is located on the northwest side of Gilmore's Mill Road, further identified as Route 708, approximately 0.33 miles south of the intersection of Gilmore's Mill Road and Wolf Faulkner Highway. Wolf Faulkner, of course, identified further as Route 130. Property is owned by William S. Shepard and Jennifer K. Radigan. Their mailing address is 25 Cattle Drive, Natural Bridge Station, Virginia 24579. Property is located in the Natural Bridge Magisterial District. At this time, I'd like to turn the floor over to Mr. Jason Tyree, zoning administrator for the county.
Good evening. Thank you, Chairman and members of the Board of Zoning Appeals. It's good to see you all. So as zoning administrator, well, let me start by saying, because some of you I do know from a previous life, some of you I have not met. As Chris stated, my name's Jason Tyree. I do serve as the Rockbridge County zoning administrator. As zoning administrator, my responsibility is really not to advocate for or against any applicant or neighboring property owner. My responsibility is to fairly and consistently administer the land development regulations and interpret the special exception permit as adopted by the Board of Supervisors. The purpose of my presentation this evening is to explain the zoning determination that is before you and the basis upon which that determination was made. At the outset, I would like to emphasize that this appeal is not a reconsideration of whether the USS Hilltop Solar Special Exception Permit should have been approved. The Board of Supervisors approved that special exception permit on January the 8th, 2024, and later approved an amendment to one of its conditions on April 14th, 2025. Those decisions are final or not and are not before the Board of Zoning Appeals tonight. Likewise, this appeal does not pertain to whether solar facilities or an appropriate land use in Rockbridge County, nor is it an opportunity to revisit concerns regarding property values, visual impacts, or the policy decisions made by the Board of Supervisors during that special exemption permit process. The issue before the board tonight is really much narrower than that. The question is whether the zoning determination that I made as zoning administrator correctly interpreted and implied the conditions of the previously approved special exempt permit. Specifically, the determination addressed the project implementation deadline contained in condition number 9 of that special exception permit. I feel like I'm saying special exception permit so many times. Condition number 9 states, construction of the project shall commence May 1st, 2026, and project has to be completed by June 30th, 2027. So when reviewing this matter, I examined the approved special exception permit, the approved development plans referenced in the permit, the land development regulations for Rockbridge County, the amendment approved by the Board of Supervisors, and the conditions that still remain in effect. Neither the land development regulations nor the special exception permit define the words commencement or construction. As zoning administrator, it is my responsibility, among others, to interpret and administer the regulations and approved permits in a reasonable and consistent manner. I consistently state that we have to be fair and consistent no matter which board, committee, staff member is involved. So after reviewing the permits and approved plans, I determined that construction of the project shall commence May 1st means commencement of construction of any structure or element shown on the approved development plans. Conversely, I determined that preliminary activities such as surveying, staking, geotechnical investigations, issuing permits, building permits, or similar preparatory work would not constitute commencement because those activities do not involve construction of the approved project itself. Again, the Rockbridge County zoning ordinance does not confine construction, but section 30-11 of the ordinances state, except as otherwise provided herein, all words shall have the customary dictionary meaning. So, per Webster's New International Dictionary, construction is defined as process or art of constructing, act of building, erection, act of devising, informing, fabrication, composition, also a thing constructed, a structure, form or manner of building or putting together the parts of anything, structure, arrangement. Furthermore, the word construct is defined as to bring together, to construct, to pile up, to set in order, to put together the constituent parts of something in their proper place and order, to build, to form, to make, to construct an edifice. Additionally, the zoning ordinance does not define commencement. So, per Webster's New International Dictionary, commencement is defined as an act, an instant, or time of commencing. Commencing is defined as to have or make a beginning, to start. As previously stated, the May 1st, 2026 letter determined that commencement of construction of any structural element shown on the approved development plans satisfied the requirement that construction of the project shall commence May 1st, 2026. That interpretation was intended to provide an objective and administratable standard that gives meaning to the implementation deadline established by the Board of Supervisors. The appellant argues that the work performed was insufficient or not substantially in accordance with the approved plans. While I certainly understand those concerns, my determination was not a certification that the project was complete, nor was it a determination that every element of construction had been perfectly installed. Rather, the determination addressed whether construction of a permanent project element, as shown on the approved site plan, had commenced for the purposes of implementation condition contained in the permit. Questions regarding construction quality, future compliance with engineering requirements, or whether particular improvements ultimately conform to the approved plans are separate matters that may arise throughout construction and, if necessary, through the county's normal inspection and enforcement processes. Finally, I would note that, as I stated in my determination letter, there were no known zoning violations associated with the property, nor the special exception permit at the time the determination was issued. I appreciate the opportunity to explain all this to you tonight and the basis of my decision. Myself and Chris Slayton are prepared to answer any questions the board may have regarding the zoning regulations, the special exception permit, the approved conditions, or the zoning determination that is the subject of this appeal. And if there are no questions, we would like to turn the floor over to the applicants. Thank you.
Thank you, Mr. Tyree. So I understand this correctly. Construction began on May 1st.
So we believe commencement of construction began May 1st, correct?
Okay. And construction can happen up until the deadline, which is 2027.
June 30th, 2027. That's correct.
Okay. All right.
So it could be sporadic. It could happen today, tomorrow, months from now, as long as it's completed.
That's okay. Thank you.
Yes, sir.
Okay. I believe we can have the applicant go ahead and state their case. You've got 15 minutes, by the way.
Okay.
Yep.
So it'll take that long.
Take your time.
I'm way out of my element here tonight, so I hope you'll bear with me with stuttering and fumbling and mispronunciations. First of all, I'd like to thank you for your time tonight to hear our grievance. Since I don't have a background in law, most of what I'll talk about is based on common sense and simple right and wrong. As I understand it, what I need to do tonight is show how my family is aggrieved by the zoning determination letter dated May 1st, 2026, and then explain why we believe that determination letter is wrong. So even though I don't know anything about law, I do have some notes about the Virginia Code that I think applies to this. So Virginia Code 15.2-2311 authorizes any person aggrieved to appeal a zoning administration's decision to the BZA. This statute does not limit standings to persons injured by a narrow legal issue being decided, such as commencement of construction. It asks whether the person is aggrieved by the administrator's decision. The Virginia Supreme Court has repeatedly held that an aggrieved person is one who suffers a particular injury to personal or property rights that is different from the public generally. It does not require that the injury come from the legal reasoning itself. Rather, the injury must be fairly traceable to the decision. The Court of Appeals summarized this two-part test relying on Supreme Court precedent, including Friends of Rappahannock and later cases. More recently, in Washington Gas Light Company versus Zinner, the Court of Appeals rejected the argument that neighboring landowners lack standing to appeal the zoning administrator's interpretation. The court held that at least one neighboring landowner has standing to pursue the BZA appeal because of the direct effect of this project, even though the issue on appeal was an administrative zoning interpretation rather than the overall desirability of the project. Applying that reasoning to our solar case, if the zoning administrator determined that the developer commenced construction before the deadline, that determination preserved the developer's ability to complete the solar facility. A neighboring property owner can argue, I am directly affected by the solar project. Had the zoning administrator correctly found that construction was not in a timely commenced, the approval would have expired. Therefore, the administrator's commencement determination is the administrative action that causes my injury by allowing the project to continue. My wife and I had the most direct view of the proposed solar facility of any of the surrounding property owners. Part of the value of our property is that it's in a conservation easement. It's bordered on one side by the Jefferson National Forest and the other side by almost 2 miles of the James River, which has been designated as a scenic waterway. Having a solar power plant in such close proximity and in direct view of our property will definitely reduce the value of our property drastically. Although we haven't had a formal appraisal, it's been suggested our property value would be reduced somewhere between 10 and 20%. So now to the part where I think the administrator's decision was incorrect. 3 wooden fence posts with wire installed with zip ties does not meet the definition of commencement of construction. The structure referred to is 3 wooden posts with woven wire attached. So this structure deviates a bunch from what the is on the drawings and the specifications. The structure does not correspond to any of the drawings or specifications shown on any documents submitted by USS Hilltop Solar, LLC. Installation of the fence as a first step does not align with the sequence of construction shown in Exhibit C, and I'm assuming you all have these exhibits. The woven wire used does not have the graduated spacing between the horizontal wires as shown on the drawings. Why would you specify a type of woven wire if that's not what you're going to use? The woven wire is not 6 inches above ground as shown on the drawings. 2 horizontal wire panels are zip tied together with plastic ties. Again, this is not part of the drawings specifications. On May 1st, USS Hilltop Solar, LLC sent to county staff photographs documenting the installation of the perimeter fencing. And I'm afraid I'm going to butcher your name. Is it Zappler? Zappler?
No, I'm the county attorney. I'm John Drayton.
Oh. Well, so Mr. Zappler inquired, is that right, Jason?
I believe it's Dan Sappler.
Sappler,
yes.
Okay. I thought CS was with a Z, but again. Mr. Zappler inquired if starting the installation of the required perimeter fence would be considered start of construction. Mr. Sappler asked for a zoning determination on the issue. Zoning Administration Jason Tyree said in a May 1st letter that it would. The fence installed is not the fence that Hilltop Solar will be using according to its own drawings and specifications. I'm pretty sure that this fence will not be any part of the construction of this project and will be removed if the project ever gets started. Other than to comply with the May 1st deadline set forth by the Board of Supervisors, I can't see any use for this fence, again, according to the drawings. It's literally the least the developer could do to say it's begun the project by a May 1st deadline, and I contend that the administrator was in error accepting this structure as any part of the project. The intent of the commencement requirement is to ensure timely, good faith progress, not to allow a permit to be preserved indefinitely by minimal activity. The developer USS Hilltop Solar LLC has already had to extend its timeline once. It now hopes that Rockbridge County will accept its feeble attempt at meeting its deadline of commencement of construction with a fence that doesn't correspond to any of the specifications on the drawings. As a Rockbridge County resident, I'm disappointed that we might accept this weak attempt. And I don't think that's how Rockbridge County wants to do business. I would hope not. I appreciate you all bearing with me. Is there any questions?
Well, Mr. Jeffer, I couldn't agree with you more. A solar field is an ugly sight. And I have to look at one every day when I drive through Fairfield. And quite frankly, it's the property owners that make money and the company that builds the solar. Because I see solar companies selling between other companies several times. So I understand your grief. However, I also respect our county administrators and Mr. Tyree's position about what his stance is and what dictates construction and when construction can happen, between the start date and the end date. I think he's absolutely right. The 3 posts and the fence are pathetic. They probably don't have anything to do with the final project, but I think the solar company did what they had to do to show that the project was started at a date, on time. So anyway, I feel for you, sir, and I feel for your wife.
Well, and I'd like to say Chris and Jason have been very helpful and kind throughout this whole project. I have no matter how this comes out, I have no bad feelings toward them and respect that they have a very difficult job to do. No way they can make everybody happy. But like I said, I feel we are aggrieved by this decision, and I don't think that was a real attempt to start the project.
I agree.
Because it's not shown anywhere on their plans or specifications. And, especially with a contentious issue like a solar farm in this county. And as we know, the zoning, I guess that's the right word, has already been changed on what's required of any future solar farms.
Yes, sir.
I would like to think with that contentious issue, we would hold to some fairly high standards, which this does not.
I understand. I appreciate it.
Thank you.
At this point, the respondents' presentation.
Thank you, Mr. Chair. I'm John Dryden, the county attorney, and we spoke a few months back on
Yes, sir.
a similar thing. Actually, I have to tell Mr. Jeffer, for not being a lawyer, he did an excellent job. I think that was the best presentation we've had from the BZA, and one that was well thought out and well reasoned. And many of the points he makes are good points. They are good points. But when we come down to determinations that have to be made by the zoning administrator, and it's particularly the issue that's before the Board of Zoning Appeals, your authority is limited to making a determination whether or not the zoning administrator was correct.
Yes, sir.
And there also is another. I think I'm very I think Mr. Jeffer, I'm glad that he addressed the issue of aggrieved. That was well done, and he cited the correct case and the correct law. The issue, though, comes up as to what actually aggrieved means, which we didn't actually get to. To be an aggrieved party, you have to be able to point to a particularized harm that's not a general harm that would apply to everybody throughout the county. You have to point to that particularized harm that arose from the determination of the zoning administrator. It's not a particularized harm that might come from the fact that the Board of Supervisors already granted this special exception permit. That's not the issue. And now I realize that the points he's made are good points, and I understand the situation where he stands. But the fact of the matter, he has not addressed any particularized harm that will come other than the fact that that this very well may result in the finishing of this and seeing the solar panels in close proximity to his home could reduce the value of his view shed and reduce the value of his property. That is a question that should have been brought before the Board of Supervisors at the time when they made the determination to grant the special exception permit. And even more so why this isn't applicable now, even if the applicants in this case were not unable to commence construction by May 1st when they were supposed to, it doesn't result in the special exception permit expiring. That doesn't happen, which means is they're now in a position where the zoning administrator has to send them a letter saying you are out of compliance and you must bring this in compliance by such and such a time, or the county will take whatever actions we're allowed to take. One of the actions we are not allowed to take is to revoke the special exception permit. We can't do that. The only way that can be done is for the Board of Supervisors to actually go through the process, hold a public hearing, and stating with justifiable reasons revoking it.
Yes, sir.
And the question is whether or not missing the commencement deadline when you have until June 30th, 2027 to finish it is a justifiable reason is not what's before us right now.
Correct.
And so even if the fact that the zoning administrator made the determination that this was the commencement of construction did not result in any harm to anyone in that particular area. And that's well, the project itself, they may point to saying that, but that was a political determination by the Board of Supervisors. And my job is not to opine as to whether that's good or bad. My job is to support the Board of Supervisors in the determination which they made, and they did do it lawfully and correctly. So our position is that on the threshold issue as to whether or not the appealants here are actually aggrieved parties, I do not believe they meet the statutory definition and the definition as defined by the various court cases which discuss aggrieved parties. He is correct that the Supreme Court has taken a broad view as to whether or not you're in close proximity, because the rule is you have to be in proximity and suffer a particularized harm. It used to be some of the older cases, they interpret proximity as being closer. Now the Supreme Court has determined a broader definition of proximity, and also the issue of what a harm is. But as of yet, the Supreme Court of the state of Virginia holds to that it must be a particularized harm which arises directly out of the determination of the zoning administrator. And in this case, the zoning administrator's determination has absolutely nothing to do with whether or not the special exception permit will be revoked. And the damage which they're referring to is only damage that will arise on the completion of the project. And so if the project's not completed, which as of now, whether it's complete or not, it depends on the parties which are building it there. You know, in some cases, for example, a case was before us before the parties pulled out, and it turns out they're not going to be building a solar farm there. So there is not a particular harm now because there is no completion of the project. If they could point to the 3 posts out there as causing this harm, that would be something they could actually point to, but that's not a contention they made, and that would be a difficult thing to show the actual harm comes from the 3 fences there. So that's our initial position. The next position, of course, is that the relief that they're asking for is not relief that the BZA can actually grant. The only thing you cannot deter, but even if you were to determine that the zoning administrator was incorrect in his determination this was the commencement of construction, you cannot hold that the special exception permit is therefore void. The special exception permit will still exist. The zoning administrator in that situation would just have to then issue a letter saying that you're out of compliance. You need to come in compliance, and it would not result by that act in the fact that the project cannot proceed. And so the request to make any changes to the special exception permits to otherwise halt the construction or to otherwise make changes to it, that is beyond the power of the BZA. And the only thing that you can address is whether or not Mr. Tyree correctly interpreted the condition 9 and the commencement instruction, and you are also required to give deference to his opinion. And so the applicant has to come forward with the preponderance of the evidence to show that he was wrong. So otherwise, we have to assume that Mr. Tyree was correct. And finally, on the merits, it's clear on the merits of this that is the correct determination. It's the issue at hand as to whether or not construction is complete, whether or not the particular things within the particular aspects or particular improvements were being put on the land in accordance with the site plan are done correctly, is something that could come up during the process of it going forward. They put, as far as we understand, as far as the pictures, and they proved it, seem to have proved it, and the appellant has not challenged this. They did put a fence on the exact location on the site plan where a fence is supposed to go. If they actually called us beforehand, as they mentioned in their filing, and for a discussion of what could be done. And after our discussion, we believe that we follow what McClung which was the Supreme Court case, which determines whether construction actually commences. And the Supreme Court case basically said what Mr. Tyree actually said. No, what there it says they quoted the Webster definition that construction, by its ordinary meaning, means the putting together of the constituent parts of something in their proper place in order to build, form, or to make. And the fact that there was a portion of the site plan was put into effect. There's arguments, and the arguments we made, which is a fair argument, that it was the minimal they could do to comply. But that's all they had to do. They just had to do the minimum amount to start to commence construction. They weren't required to do beyond that. Now, by June 30th, 2027, that's a hard deadline. Unless they come back to the Board of Supervisors and get that extended, they have to have everything done. If they aren't, they have no right to continue construction on that site, and they have no right to operate. And in that situation, by the very fact that they violated a condition, they would not be able to proceed with a special exception permit. It would no longer be valid for them to do that. But that's a different issue. That's not what we're facing today.
Yes, sir.
And it's clear also that the Board of Supervisors is making the determination of giving them basically 14 months in which to do construction for a project which doesn't take 14 months to do construction, that they anticipated that it would be done in fits and starts. The bits will be done here as financing or equipment or other things are available. And this was done on purpose because the USS Solar made the point that it takes time for them to source particular things. And so the board, understanding that, said, okay, we'll give you this 14-month period, and with the Office of Government Extension, but 14-month period in which you can both commence and then complete construction. So the determination made by the zoning administrator is correct. That was indeed the commencement of construction. It very well may have been the minimum. We're not arguing that point, but that's all they were required to do, is to commence. And now they're under the requirement that by June 30th they have to have it complete. And if they don't, then they either have to come back to the board, and the board will make a political decision, which is a legislative decision, as to whether or not to grant an extension, or if the board refuses to grant an extension, then the project will then fail because they cannot continue past June 30th, 2027 if they don't have it complete by then. So it is the position of the county that Mr. Tyree was correct in his determination, and that the determination of the Board of Zoning Appeals should be to deny the appeal of the applicant, and frankly, at the first stages, to question whether or not he actually is an aggrieved party for purposes of the law and has the right to have standing to bring this before the board. I'm going to grant a bit of time to the legal counsel for the USS Solar to share you received from their information on that. Oh, and I do want to address one thing. We do have, which we are grateful when members of the community send additional information in, and you did receive from the Rockbridge Taxpayer Alliance a filing similar to filings that they've provided in the past,
sure,
challenging this. While it's not part of the official document, it is treated as it should be, as citizens' comment and documents which have been provided to all of you. The 2 points which I wish to address there that Mr. Russell, president of the Rockbridge Taxpayer Alliance, has made is one. It's that the zoning administrator is not required in his determination letters to provide legal arguments for why he's there. It's not meant to be a substantial legal document as to provide the basis for his determination. He did in the letter, if you look at, he did provide basis for why he made that decision. But if you look at the statute, where he's required to provide a detailed basis is actually in this meeting. That's the only place in the statute where he's required to do so, and he did so today. So he did meet the legal point. And so the letter from the Rockbridge Taxpayer Alliance just is a misunderstanding of the law. That's not what the law requires him to do. And they also made reference to the McClung case, and it was the WA&B cases, which are the cases we had discussed before in the prior hearing. And those ones both define the commencement of construction. And he said that they're not applicable, but they are, because they do have, that is the Supreme Court case, which defines for law in Virginia what the commencement of construction is. And that is the basis by which the zoning administrator made his determination as to where this satisfies commencement. And the reason why in the other case, we determined that it's the county's position that construction wasn't commenced because there was nothing according to the site plan that was actually put in permanent place and added upon. And so it didn't meet the definition of the Supreme Court for commencement of construction. So other than those 2 points, we do appreciate the Rockbridge Taxpayer Alliance sending things over to provide additional information. And with the board's permission, I'd like to turn time over to council.
I have one question.
Sure.
Just to be clear, the quality or correctness of the construction relative to the plans is not important until it needs to be done on June 30th of 2027?
Well, yeah, and I cannot speak for the zoning administrator, but my view is, of course, it's important. It's always important every step. But however, the determination whether it meets those type of things beyond just the preliminary plat that we put a fence kind of where it was is something that will come up during the whole period. And so there will be reviews as to whether or not they're in compliance with the site plan throughout the project, and on the end of commencement the end of construction, the completion of construction. You know, if they put the height of the panels not in compliance with what their site plan says, if they put them in different areas, they would not be in that. At that time would be the time to make that determination, because they have between now and June 30th the opportunity to fix any of that stuff.
Right.
So the fence part here, you know, it's it would have been nicer if it was they put the whole fence out, but if the fence doesn't meet the complete standards of what the site plan says, they have until June 30th, 2027 to fix that.
Right. So we can't be too critical about that if they have time to sort it out.
And Mr. Jeffer was completely correct. It was the minimal effort required for them to be able to do so. And I don't necessarily hold it against them. I mean, they realize that there's certain deadlines and it wasn't there, and they're for what they've represented to us, that they're fully committed to have this project complete by June 30th, 2027. They've never said anything different. So they just wanted to make that and put minimal effort in place. And they asked us what we thought it might be, and we provide what we thought it might be. And then when they sent pictures in and requested that we make an official determination. So I believe they put forth the effort, at least to that area, to confirm that indeed that this would meet what the minimal requirement would be to commence construction. And so I think they did that appropriately in my mind.
Another question for you. Does this in any way set a precedent for what the start of construction can be in the county, or is this very specific to this project based on their special exception permit? Because 3 posts to me is like, that's a very low bar. Yeah. And what if a builder now runs into, oh, you put up 3 posts, now you should have had a permit or something. You know what I mean?
Yeah, and that's a little bit different, because, you know, if the builder were to come in and say, look, and they had, because most builders don't have these requirements, don't have a special exception permit with a condition that says you have to have commenced construction by such and such date and finish by such a date. That's not part of the permitting process for a normal builder. Yeah. And so they can argue if for some reason something comes up saying, for example, that you have to commence construction because some change the law by such and such a date, which is exactly what happened in the McClung case. You know, the veterinarian tried to build a clinic and he received permit to do it, but he had to have it started by a certain point and he just didn't do it. Mm-hmm. And so if that case, then this could come up, they could argue at that point that we put a fence in, which is part of site plan, which was approved, therefore it is commencement. And then they did have the ability to argue that, and that would be something that probably wouldn't come before you all unless it was off a special exception. But no, to your question is this is a particular determination, as all zoning administrative determinations are, which are not binding on future applicants, and it is particular to condition 9 of the special exception permit, which this particular applicant had received. And so it would have no impact whatsoever on other projects that go out there, except for, I think we do believe our position is correct according to the law, and so we will always try to interpret whatever facts are correct according to law. But every facts are applied to the law in a particular case and a particular requirement. Not every special exception permit has the same conditions on it.
So at most, it could apply to a similar project, like maybe another solar project.
It wouldn't even in theory apply. It wouldn't be precedent. In other words, it's not
Okay.
legally binding. If we make a determination otherwise in a different way, that's fine. We have the right to do so, and the zoning administrator has the right to do so. So we apply the facts to that area. However, it would be, if a very similar set of facts came forward, it would be unusual for us to say, no, this isn't the commencement. But our view still is, the main issue is the completion, and that at the stage of completion is in compliance with substantial compliance with all the site plan issues there. But no, this sets no precedent. It definitely doesn't impact a normal builder because they're not building under these situations. And it doesn't limit the county's ability to say, well, some group come and say, we put in, 3 fence posts and did this, and so we meet the rules. The county has the right at that time to look at the particular facts and say, no, you cannot cite this particular thing as evidence. Just like we can't refer to the Warm Run, which is here before, as evidence of what it is. But we do want to be consistent. As a county, we're very careful to be consistent in our determinations. So under a similar fact pattern, we probably would decide the same thing. But no, in the end, that's the zoning administrator's determination, not mine.
Thank you.
Thank you. All good points.
Okay, thank you. So if it's all right, I'd like to turn time over to
Yes, sir.
Mr. Branson.
Good evening. Thank you, Mr. Chairman and members of the board. My name is Andy Brownstein. I'm with the law firm of Green Hurtlocker, and I appear on behalf of USS Hilltop Solar. We previously submitted to this board written materials in support of a denial of this appeal, and in my time allotted, will briefly, very briefly, summarize our position. And we appreciate the county providing us a portion of its time. You'll bear with me, but you'll have heard some of these arguments both by Mr. Dryden and Mr. Tyree, so you'll hear some of these same points again, but it will be brief. I do want to begin by emphasizing what this appeal is, and just as importantly, what it is not. This is not a rehearing on whether solar energy is good policy. It's not a new hearing on whether the Board of Supervisors should have granted the special exception permit. And it is not a proceeding in which this board is being asked to weigh view shed, property value, or other project opposition issues that were matters for the Board of Supervisors when it approved the permit. This appeal is much narrower. The only question before this board is the question set out in Virginia Code Section 15.2-2309. Was the zoning administrator correct when he issued the May 1, 2026 zoning determination letter? Under that same statute, the zoning administrator's determination is presumed to be correct, and the appellants bear the burden of rebutting that presumption by a preponderance of the evidence. If the appellants have not carried that burden, the determination should be affirmed and the appeal should be denied. There are 3 reasons why this is the correct result. First, while it is unclear what exactly the appellants are appealing, it is certainly the case that the appellants do not have standing to make this appeal. They are not, quote, aggrieved, and we've heard this term a number of times already this evening. They are not aggrieved by the decision of the zoning administrator in its zoning determination letter. Claims of indirect harm from a solar project hundreds of yards away are not enough to make the appellant aggrieved in the meaning that this term has in the Virginia Code with respect to a zoning determination letter. Not liking the special use permit issued in 2024 does not make the appellants aggrieved by the zoning determination letter. Denying the special use permit, which is really the ask here, is not on the table. This board's appellate jurisdiction is limited to the administrative decision before it. The appeal should be dismissed on the basis of standing alone. Second, the relief the appellants request is not relief this board has the authority to grant. It is difficult to tell exactly what the appellants were appealing because their applications materials did not, quote, set forth the basis of the appeal, unquote, as the statute and form instructions require. The only possible appeal here, as I said a moment ago, is of the zoning determination letter. But this appeal asks in substance that the county deny the permit. This the BZA cannot do. The special exception permit was granted by the board. This board is not sitting as the Board of Supervisors and does not have the authority in this appeal to revoke, deny, or reconsider that permit in any way. The board's role is limited to deciding whether the zoning administrator was correct, and the zoning administrator is presumed to be correct. Correctness is the statutory question, correctness about his interpretation of the condition of the special use permit, and it is the only question that needs to be answered here. Third, the zoning administrator was correct on the merits of that question. Condition 9 required construction of the project to commence by May 1, 2026, and as stated previously, neither the ordinance nor the permit defines commencement of construction. The zoning administrator therefore applied a reasonable common sense meaning of what it means to commence construction. He held that commencement of construction includes commencement of construction of a structure or element shown on the plans, including the required perimeter fence. It also expressly excluded preliminary preparatory and investigatory work. There's certainly no preponderance of the evidence that this interpretation was incorrect. It is worth noting, as Mr. Dryden also mentioned, that in relying on the letter, USS Hilltop built the section of the fence in a timely manner, satisfying condition number 9 of the permit. Then, in good faith, a few days later, the company sought to confirm that the fence was built in conformity to the zoning determination letter. And after receiving the information that the company sent on, the zoning administrator confirmed that the construction activities associated with the fence that was installed did commence construction and thus satisfied the initial commitment deadline of SUP condition number 9. For these reasons, the appeal should be denied. To summarize, first, the appellants have no standing to appeal the determination letter. Second, the appellants are not really appealing the zoning determination letter. They're asking the Board of Zoning Appeals to essentially deny the permit, which is something the BZA does not have the power to do. And third, the zoning administrator correctly interpreted and applied condition number 9 of the special exception permit. And we respectfully ask the board to affirm the zoning administrator's determination. Thank you. Be happy to take questions, Benny.
Thank you for your time.
Thank you.
Mr. and Mrs. Jeffer, you're welcome to come back up and rebuttal for 5 minutes if you like.
Just real quickly, I won't go through reading the whole thing of why I think I'm justified as an applicant, other than I can say there are literally hundreds of thousands of dollars of my property value that are potentially at stake here. Now, a certified appraisal similar to what you do on a conservation easement would show that. So like I said, as I've already described, I think I am certainly aggrieved by the definition. The second thing I would like to say, this is kind of a direct quote from the Rockbridge County concerning this. And it says in item 8, under item I, commencement of the construction of any structure or element shown on the approved development plans referred to in condition number 1. So my contention is they didn't construct any element that's shown for on their drawings or specifications. Again, it's a contentious thing, these solar panels, and I think we need to hold to a high standard. So I understand all the stuff that this doesn't automatically throw the whole thing out of the water, but I do certainly think we need to hold proper standards, and maybe at the very least, there's kind of been a little bit of a, the project's been delayed, and then now this little thing, I worry who the county's dealing with. So thank you again.
Thank you, sir. At this time, I'd like to open up to a public hearing. If there's anyone physically present that would like to speak.
There's no one signed up, but we're working on everybody in the public at this time.
There's somebody on the computer.
Yes.
That's next. Yeah.
Jeff, is it appropriate for us to ask questions of county attorney?
Oh, yeah, we'll take some time. Yeah. Did anybody want to speak? Okay.
Hi, I'm Tracy Hip. For anyone who's been at all of these meetings since this stuff started, I'm probably a familiar face. I live even closer than the Jeffers. I am the person who it's basically happening in my front yard. So I am in full support of the concerns that were raised here. I share the same concerns as do my neighbors. This is like literally feet from my front door, which is glass and looks out onto this area. I could tell you if construction had commenced, it's incredibly disingenuous to say that any construction on this project has commenced. Therefore, it seems just like common sense that they're in violation of that initial agreement and that some action should be taken. I am also no lawyer, but again, just wanted to voice my concerns, which are shared with the Jeffers, which are also shared by some of my other neighbors who aren't here because they didn't know about the meeting. But it is a disingenuous claim that also does not provide a lot of good faith for what this project looks like going forward over the next year plus. And it's also really difficult for me to figure out what to do with my own property over the next year because of how much it is impacted by this project. So sorry for the rambling. If you have any questions, let me know. Thank you for your time.
Thank you. Is there anybody else? Okay, at this time, I'd like to take comments via computer or the telephone.
Is there anyone online?
There.
Okay, sorry.
Mr. Bill Russell had his hand raised. So, Mr. Russell, can you have the floor, I believe.
Can you hear me?
We can.
Okay, thank you, Chris. Thank you, board members. I'm here, Bill Russell, president of the Rockbridge Taxpayers Alliance. We are not parties. We're not speaking on the merits of the case. We do have some interest in speaking on the process under which this is taking place. We filed written comments in rather specific pointed directions, and we do agree that the determination letter itself is what is under discussion here. So any authorities cited after the determination letter really are not in the determination letter. And yes, the determination letter probably should have some authority behind it besides the authority of the staff citing itself as the authority. I think there's also probably some recognition here that there's an inconsistency that this same board has heard on two different determination letters, one in which heavy equipment and movement of foundation, sub-foundation work and so forth was declared not to be construction, and one in which on a one-day period when 3 fence posts were placed in place was declared to be construction. I just want to note the difference in that because I find it rather interesting. What, however, I'm more interested in is that the staff letter in the determination acted to narrow one of the conditions, or two of the conditions, in fact, that the Board of Supervisors placed on the applicant. And it's our opinion, and I would like to note that I did understand Mr. Dryden to say that I was wrong on the law, we're wrong on the law on two separate things, and that is his opinion. And my opinion is quite obviously, since I put it in writing, quite the opposite, and we did that to place this on the record. and it will remain a part of the record here. But the narrowing that occurred, it happened when they changed the object of the condition. The board referred to construction of the overall project. The determination asks where the particular permanent structure element has been constructed. It excludes activities that ordinarily may be part of project construction. I don't believe, and things like clearing, grading, and so forth, I don't believe that the staff, through the determination letter, has the ability to properly act in narrowing conditions placed by the board. That's a board act. And that's an assumption of an act that they have no power granted to them that I can see by the Board of Supervisors, or that they can act on under Dillon. It substitutes a permanence requirement. Nothing in the abbreviated conditions shown in the staff report says the first construction activity must itself be a permanent improvement. It creates a safe harbor act. Installing some portion of the perimeter fence apparently satisfies commencement, regardless of whether meaningful construction of the generating facility has begun. It reduces the board's deadline for project performance requirements to a technical vesting threshold, which goes into another part of the argument. Instead of requiring actual commencement of the solar project by May 1st, the determination allows the developer to preserve the permit through a comparatively minor qualifying act. I think there's one essential documentary qualification here. The termination letter asserts that the detailed definition appeared in the April 14th SEP ordinance itself. The uploaded Hilltop conditions document appears to be the staff report and recommendation, not necessarily the complete executed ordinance. If the board adopted ordinance actually contains the quoted permanent structure language, I would, and I'm merely saying this because I pulled it up, and I'm not sure that it does because I don't see it before me. Then, in fact, they've narrowed the ordinance that was drafted for and adopted by the board, and I think that would be on their power. As to the other portions of this that are before the Board of Zoning Appeals, we're not going to express an opinion. As I said, we're not a party, and our comments are here or merely to advance what we believe is a public interest in the process as it occurs for applicants and for public participation. So thank you.
Thank you, Mr. Russell.
Thank you.
Is there anyone else, Chris?
If there's anyone else online that wishes to make a public comment, please utilize the raise your hand feature now. I'm not seeing any others.
Okay. At this time, I'd like to open up for board members to ask any additional questions and have further discussions. Roy, you wanted to.
Yeah, my question is, maybe it's not a question, maybe it's rhetorical, because I directed at our county attorney. If we think about this case, we can go back in time and think of other cases that were similar that had different names. For example, cell towers. And so the question is, or that I have in the long run, if we're not satisfied with how things worked out here, which we may have to chew and swallow, is it appropriate and is it legal, is it advisable for a group of citizens to say, this didn't turn out the way we thought it should have, but there are still other fields that might be enticing solar powers. Maybe the next one's generators, data centers, and stuff like that. Can I imagine this zoning that we're working under tonight was invented before cell phones were invented. And over the years, things have happened, and now we find out that it's permissible to have a solar field in A2 zoning, or to park junk cars in A2 zoning and stuff like that. So the question, shorten it back to where I started. is it appropriate and is it doable that citizens can say to their supervisors, we'd like to see the zoning laws amended to reflect that we're in different times, different things happen.
Yeah, and that's actually the proper way to approach it. Now, to be frank, the board of supervisors only have the ability over the local zoning laws, and there's changes. For example, you raised the question of solar power and agriculture zones. With recent changes in the law, solar power, which use a ground-mounted solar power that's below 1 megahertz, we have no right to stop that from happening. Prior to that, we did have restrictions under our solar ordinance was adopted as to area, had to be half acre, anything above that we had to. But we don't have that authority anymore because of what laws changed in Richmond. So if citizens of the county have concerns, they can not just petition the supervisors, they can also petition their senator and representatives if they have concern about it. But I think you raise a good point. Those general issues are political issues that should be handled by the legislature. They're legislative issues and not ones that are really judicial issues. At this stage, we only can apply the law as it is written. And as lawyers, I mean, we get a bad rap at times because we have to read the law as the way it's written, and that doesn't, which often means there's people that are going to disagree with you and people that agree with you. But I mean, that's just throughout my little 2 cents, that's the way society works. I mean, we can only have law. Somebody has to interpret the laws. We have to say what they mean. We have to be consistent in how we apply them. And so it's that's the job that we have. But changes that you made, that's a good point. There is avenue, but and also here, I mean, I think it's fine to throw out here. If Mr. and Ms. Jeffer are not pleased with the outcome here, they do have the right to appeal that to the circuit court. That's built in there. The legislature did put laws in place to the extent possible to protect people's rights, to make sure that people get fully heard. That's part of the reason why the BZA is here and why an appeal to the BZA is really relatively a simple process, is because it's important that people can have their views heard. So, Mr. and Ms. Jeffer bringing the points they had to bring is exactly what the law anticipated. Whether we take a different interpretation of what they had and believe the law says something different, that's another issue. But they clearly have the right to do what they're doing.
Any other questions? Okay. At this point, if the board feels that we need to go into a closed session, this would be something that we would vote on. If you don't feel this, don't make a motion, and we'll just go ahead and make a vote. So is there any motion? Chris, did you want to say something?
Yes, no, I apologize for interrupting, but we are still, the public hearing is still open.
Oh, okay. I'm sorry.
We formally need to close that.
And any other questions? Okay, I'd formally like to close the public hearing and input. Thank you, Chris, for reminding me. So if anybody would like to go into closed session, this is the time to make a motion.
We don't get to speak before this evening, the folks up here. So I think it would be beneficial for me to go into a closed session with our county attorney or our board attorney, I should say, right? You get to stay with us?
Yes. The closed session would be for legal advice from you.
Yeah. Right. But we would be able, all four of us would be able to be in here to ask you a question, right? And all could hear. Yeah. And then will we just make a motion after this or have any amount of discussion or anything?
Yeah, we could have discussion and then make a motion following and letting everyone listen, or we can go into closed session, which just leaves us in here and we consult. If we have any legal questions, we can consult the attorney.
Mm-hmm. Well, I would make a motion to have a closed session just to clarify something.
Okay.
If you don't mind, we have a checklist and form for a motion for closed session.
Yeah,
in
I
front
can
of
do
each
that.
of y'all.
Sorry.
Yeah.
I move that the Rockbridge County Board of Zoning Appeals convene in closed session to discuss the following. A matter involving consultation with legal counsel employed or retained by the board regarding specific legal matters requiring the provision of legal advice by such counsel pertaining to the appeal of the zoning administrator's decision pending before the board.
I'll second that. All in favor?
Aye.
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 Nay? Okay. So at this point, what we'll do is we're going to go into closed session. And yeah, Chris, if you could
Reconvene.
go ahead and yes, sir.
Reopen.
And we'll let you know. We'll come back. Somebody will come out and get you when we finish our closed session. Thank you, folks.
We always say, Christian Turner.
I'm gonna go to the doctor tomorrow morning. This thing in my tongue is really bothering me. I showed it to you before, it's still there and it kind of hurts.
Could it be herpes? Oh, that purple. Okay.
I mean, what it is. I'm worried about this bad water. No, I don't. John will piss me off and I let him. He said, he started talking about the file. He said, oh, I just need to mention the file. He said, yeah, it's here and it's there, you can read it, but they don't really understand the law. You know, I came on, I went off, he said, you know, I'm here from Rockbridge County, blah, 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 blah. I said, I'd like to say that what we said about this, we put in writing.
All right, are we ready? Technically, Chris?
Yes, sir. Yes.
Okay. At this point, we need to have a BZA member make a motion to return to open session.
I make a motion. Return
All
to
right.
open session.
All in favor?
A second.
Second? Aye.
Aye.
All right.
Could I say briefly too, I may have misspoke before we took the break. The four of us don't speak and can't speak about the matter privately. And in the closed session, I had a specific question for the attorney that serves the board. And frankly, it was a dumb question and I didn't want to send us down a rabbit hole. And so I'm just glad I got clarification and didn't distract from the matter at hand. So all of our conversations between the four of us happen in the room, and that's required by law. So just want to clarify that because I might have made a comment that confused or could have been confusing prior to the break. So thanks for giving me a second to just say that.
I move that the board
I would say to that point.
Yeah, I move the board certify that in the closed meeting that just concluded, to each of the members' knowledge, nothing was heard, discussed, considered except the matter specifically identified in the motion to convene in closed session and lawfully permitted to do so, discussed as exempt from open meeting requirements under the provisions under the Virginia Freedom of Information Act cited in that motion. Did you all want to have some more discussions regarding this?
So that has to
I
be
would
voted, that
second
motion
your
has to be
motion.
seconded and voted
I
on.
would
Oh.
second your motion.
Okay. I apologize. All right.
I second that.
All in favor?
Need to do roll call.
Oh, roll call? Yep. All right.
Aye.
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 It might be best if you just call it each person's name and have them opportunity to say that. That way it'll be on the record.
Okay.
Sure. Board member Faber?
Yes.
Board member Mullen?
Yes.
Board member Powers?
Yes.
And board member Pufall, yes. Thank you for the clarification. This is a very, for the adjacent property owners, I feel for you. I do. This is tough. Nobody wants to see a solar farm or change in a beautiful community or a beautiful setting. On the other hand, I do feel that our that the definition of construction was well laid out. Well, I do believe that the solar company's meager attempt to begin that construction, I just said it all. I used the word meager. Was an act of construction. So I just want you to know that I really do feel for you all in this case. Anybody else?
Yeah, I would just echo what you said. I think it was very well spoken. I really feel for you all as adjacent landowners. I'm adjacent to, our farm is adjacent to Barks solar array. It is a smaller array, but I would say you're very wise to pursue these legal avenues that you have. So good to do that and have a history of having done that. And I agree that this seems like a very low bar, 3 little posts out in the field. And by the same token, maybe a sign that there's not much to come. They don't have that much time. And I don't think the start date, I think is an interesting point to hang the legal matter on. I think the county's argument that the start date being meant by these 3 posts does make sense. Although it is very unfortunate. I think obviously the bigger date will be the end date and that not getting pushed down the road, hopefully for you all. But obviously that's not up to this board. So, yeah, I just wanted to make that clear that there's only so much in front of the board tonight of zoning appeals, and that a lot of this is, Board of Supervisors questions and issues. So feel for you guys. And I can tell you just have spent a lot of time trying to read and understand all these legal issues as much as my farmer wedding venue owner brain can. And so, yeah, I feel for you and I hope for the best in the future for you all.
Any other comments? I think our county attorney did a great job presenting himself as well as Mr. Tyree. Thank you for your input this evening. At this time, do we have a BZA member that would like to make a motion? And in front of you, you have a variety of motions.
I move to dismiss the appeal of Donald P. Jeffer Jr. and Janine L. Jeff for lack of standing. Neither the applicant is a person aggrieved as defined by the Code of Virginia, 15.2-2311A. I think, I guess I have comments afterwards, but that's the motion.
Okay, so a motion's out on the table. Roy, you second that motion? Is this a roll call? No? Okay. All in favor?
Aye.
Aye.
Aye. Opposed? None. Okay. Did you want to say anything else?
I mean, if this decision comes down to the Code of Virginia and the zoning administrator's job as defined in that, I think I wish we had more leeway, but we don't. It's a, I guess as was just as said, a narrow issue.
Okay. Thank you. At this point, I would like to open up the table to other business. Chris?
Yes, I do have something for you. Don't mind. We are in the process of updating. Back to microphone. Twofold. One in front of you, we have revised the application of appeal of a zoning administrator's decision. You may recall the other one was part of the administrative action form. We have separated this out, and we're planning to do the same with the variance. We have a rough draft with the variance, but we have not finalized that. But those are, of course, the two actions that come before the Board of Zoning Appeals: is appeal of the zoning administrator's decision and the variances. So I just wanted to share with this revised application with the Board of Zoning Appeals member, and then also state that we're going through on the 27th of this month, we're going through the public process of revising the fee schedule. So we're going to slightly increase the fee associated with the appeal of a zoning administrator's decision. Of course, that helps defray some of the costs that we accrue. Secondly, we are going to, like most localities, we are going to start charging for a determination letter. I think it's fairly nominal, $50 if I recall correctly.
I can't remember.
I can't remember either. I apologize. I should have had that information in front of me, but we are going to start having a fee associated with the determination letter. That we obviously take each one of these as unique as they are. We take them very seriously, and it takes some time for the investigation work done by staff, and then prior to starting drafting the letter itself. So that's what I wanted to update y'all on, the new application and the revised fee schedule.
Thank you. Any other business?
Not at this time.
All right.
Not for me.
Okay. All right. At this point, I'd like to adjourn the meeting. Thank you. Thank you.